Constitutional Court yesterday ruled that the Electoral Act is unconstitutional. This paves the way for independent candidates to run for national and provincial elections. The court ruled that the current act doesn't allow for adult citizens to be elected to national and provincial legislatures as independent candidates, and this is inconsistent with the Constitution. So what does this mean practically? For more on this, I am now joined by constitutional law expert, Professor Pierre de Vos. Professor, good afternoon. Thank you very much for joining us. I mean, everyone seems to think that we can now all raise our hands and contest elections. I mean, is this the real case? Prof, just looking at that ruling by the ConCourt, unpack the reality of this for us, please.
Okay, so what the court said is that the existing system, which we have at national and provincial level, which is you vote for a party, the party has a list of candidates, and then the people who are high up enough on the list, given how many votes they get, go to parliament. That system is not acceptable, that it's unconstitutional, because independent people who don't belong to a party cannot stand in the election. So Parliament now has 2 years to fix the system and to make some kind of system where at least some of the members of Parliament are elected probably in constituencies, so that you as an individual go to Parliament because you were voted in specifically in your own name as a representative of a party often. From that constituency. So, but how it will work we don't know yet, because Parliament must make a new law and devise a new electoral system.
Prof, the state has three arms, as we know. There's the judiciary, there's the legislature, and the executive. I mean, the judiciary arm has already been enforced. It's interpreted the law. What is the role of the legislature as well as the executive at this point in order to perhaps bring this ruling into effect?
So the Constitutional Court has now said what cannot happen, and that is the existing system cannot continue. And then now what's going to happen, the executive, the president, the cabinet, ministers, whoever, they're going to probably come up with some kind of plan. They're going to consult. They're going to present a draft law to Parliament. Parliament is then going to consider it, and then they have to pass it. It will have to happen in 2 years. The court is not involved in deciding the nitty-gritty of the electoral system and the law. That is for Parliament and the executive to do.
All right. I mean, ultimately declaring an electoral act unconstitutional, it's a serious finding, especially by the highest court of the land. Looking at some of the loopholes, the legal loopholes, that this ruling perhaps has now opened up, are there any legal avenues which might be explored by anyone, perhaps in regards to the processes, the outcomes, which perhaps might be attained through using this Electoral Act, but obviously has now been found to be unconstitutional?
Yeah, that's interesting. The court thought of that, and they said if they declared the whole thing unconstitutional, it would be unconstitutional from the day that it came into effect, and all the elections that had happened in the meantime would be invalid. So they said, no, we limit the invalidity up from the day where the judgment was made. So all those other elections are valid. They're going to remain valid. You can't challenge them. And also, of course, because the local government election has a different electoral system, this judgment won't affect that system.
All right, and then, Professor, just looking at the running of the electoral system at large and perhaps the leadership in the executive and legislature arms, I mean, do you think, based on that timeline that have been given, it will ultimately be enforced? And also, what does that look like?
Well, the problem is they have 2 years, because this is going to be a complicated policy decision. It's going to be consultation, so it's going to take some time. But the court has given them 2 years. If they don't finish in 2 years, they are in contempt of court. So it will have to be done. Also, because it needs to be done well in time for the general election in 2024.
So speaking of, some of the delayed tactics that could come into play, I mean, just citing a case in the lower court, I mean, it was the Western Cape High Court back in 2019 that also dismissed this case. I mean, ultimately, are there any possibilities that, the legislature, the executive could perhaps use to further maneuver and delay some of the regulations that had been enforced and avenues that the armed state perhaps could possibly use to delay this implementation of the ruling?
Well, what they can do, of course, if there's a two-thirds majority supporting it, they can amend the constitution to make sure that the current electoral system remains constitutionally valid.
Okay.
But for that, they would need two-thirds majority, because to change the constitution require that. Otherwise, they don't really have a lot of options unless they after 2 years, they go to the court and ask for an extension, but the court is really not happy with that and they really give them a hard time. So I think they were going to try and finish within the 2 years. The trick is what system are they going to come up and which political parties will it benefit, because that is what one will have to look out for.
All right, Prof, let's leave it there. Thank you very much for unpacking that. Of course, the unconstitutionality of the Electoral Court, unpacked by Professor Pierre de Vos for us.